concept of citizenship is much wide, but it is much wider when you talk about India. So today's video we're going to understand regarding what citizenship is, what citizenship is mentioned under the Indian Constitution. So let's move into the very broad topic of today, that is citizenship. So before entering into the mode by which we can acquire the citizenship or we can terminate it, first we need to understand the valid term and its meaning along with its significance. So we'll understand in the simplest manner possible, which has been mentioned in Indian Polity by Lexicon. So this slide is about meaning and significance of citizenship. Like any other modern state, India has two kind of people, citizens and aliens. So it says that India has two kind of people. One is citizens, that we are all familiar with the term. That one is alien. So here alien is not that we have seen in Hrithik Roshan movie, that is Jadoo. That is not kind of alien that has been mentioned here. So it's basically a kind of a person which is termed as aliens. So now we will understand the about alien in much wider sense. Citizens are full members of the Indian state and all allegiance to it. So citizens are the people who enjoy all kind of rights that has been mentioned in the Indian constitution. They enjoy all civil and political rights. So everything, be it a civil, be it political right, they have the right to enjoy both of them. Aliens, on the other hand, are the citizens of some other state and hence do not enjoy all the civil and political rights. So just now I have talked about Jado, this could bhoop chahiye tha. So basically alien is a person who has its origin from another country and they are not native to our place. These people are considered as alien. They are of two categories, friendly aliens or enemy aliens. Now they have also two categories in them. One is friendly and one is enemy aliens. Now let us understand what is friendly aliens and what is enemy aliens. There are two aliens. So friendly aliens are the subject of those countries that have cordial relations with India. So friendly aliens are those with whose countries we have a good relation. Our India has a good relation. India enemy aliens, on the other hand, are subject of that country that is at war with India. So, if we talk about Pakistan, we or some days ago was at war with Pakistan. So, the people, if they come to India, they'll be considered as enemy aliens because they are from such kind of country with whom our country is having war with. They enjoy lesser rights than the friendly aliens. So the kind of rights that we have given to these friendly animals will be giving less rights to this alien, this enemy alien, because our country is not in good terms with them, so that's why we are not offering them all the rights that we are offering to other people. For example, they do not enjoy protection against arrest and detention, which is given under Article 2. So this is one kind of example that they are not protected. Right against discrimination. The Constitution confers the following rights and privileges on the citizens of India and denies the same to aliens. As I said, if you are a citizen of India, there are certain rights that has been given to you by the Constitution itself, and they are not given to the aliens and who are from other countries. So these are some of the rights that has been mentioned with article. Right against discrimination on ground of religion, race, caste, sex, or place of birth. So on Article 15, I have already made a detailed explanation. You can go and check its detailed elaboration. Then we have right to equality of opportunity in the matter of public employment. Article 16. These I have already discussed, so I'm not gonna add that kind of lectures in this video itself. You can go and refer those. Right to freedom of speech and expression, assembly, association, movement, residence, and profession, which is given under Article 19 and which is only for the citizens of India, not for any other person who belong from another country. Cultural and educational rights, Article 29 and 30. So basically, Article 29 talks about some cultural and educational rights given to the citizens. Right to vote in elections to the Lok Sabha and State Legislative Assembly. So like that we have the right to choose our representative by the media throughout the medium of casting our vote. right to contest for the membership of the parliament and the state legislature, and also we can be a part of such legislative assembly. Eligibility to hold certain public offices, that is President of India, Vice President of India, judges of the Supreme Court and the High Courts, Governor of States, Attorney General of India, and Advocate General of India. So these are some high qualified posts that we can opt for because we are the citizens of India. So we are eligible for such posts. The very requirement is fulfilled when you become the member of India or a citizen of India. Along with the above rights, the citizens also owe certain duties towards the Indian state. So now we are the citizens of India. We have certain rights given by the Indian Constitution itself. So if we have some rights, at the same time we should be given some duty also. It's not like that we are winning or we are only winning and there is from our part there is no such responsibilities. But there is, if you are enjoying some certain rights, then we want from you to follow or be obedient to certain duties as well, and they are paying taxes. So we pay taxes to our government so that they can run the government well, run the state well. Respecting the national flag, we have to respect our national flag or national anthem, defending the country, and so on. So these are the some examples given that which will be added as the duties of the citizens. In India, both a citizen by birth as well as a naturalized citizen are eligible for the office of president, while in USA only a citizen by birth and not a naturalized citizen is eligible for the office of president. So this is basically a kind of differences between USA and India for the post of the president, who can add himself on or who cannot. So now let's move into the constitutional provision which has talked about citizenship, which now we have already discussed, but now we are going to understand it in a more detailed manner. The Constitution deals with the citizenship from Article 5 to 11 under Part 2. So this is a very important thing to remember. From what article we have citizenship, that is from 5 to 11, and which part? Part 2. So these little things have the probability to come in the MCQ questions. However, it contains neither any permanent nor any elaborate provisions in this regard. The Constitution only talks about that from 5 to 11 which deals with citizenship, but it's not in a detailed mode it has been given. It says that it only identifies the person who becomes citizens of India and its commencement. So it says who will be the citizens of India when the constitution was adopted. It is on January 26, 1950. It does not deal with the problems of acquisition or loss of citizenship subsequent to its commencement. So it doesn't cover all other stuff that is come along with the citizenship. It says that the parliament will see it as other thing. We are only saying that from this article, from this part, we are having citizenship, and among these, whether the other thing that will be included, the parliament will look after it. It empowers the parliament to enact a law to provide for such matters and any other matter relating to citizenship. So basically the Constitution of India said it's up to parliament. They will do whatever it feels right, and they will make laws, they will do amendments, they will say who will become the citizens of India, who should not be eligible for the citizenship of India. So all these powers have been vested to the parliament only by the constitution itself. Accordingly, the Parliament has enacted the Citizenship Act 1955, which has been amended from time to time. So, after the independence, after we got this Citizenship Act, that is 1955, which has been mentioned that who are the people who will become the citizens of India, and which has been amended from time to time, because from that period to now there is lots of changes that has happened. So on that basis it is important to modify the citizenship amendment act from time to time. So let's see what are the provisions that mentioned under Citizenship Act 1955. According to the constitution, the following four categories of person became the citizens of India at its commencement, for example on January 26, 1950. So in the Amendment Act 1950, there has been mentioned only four categories. For example, a person who had his domicile in India and also fulfilled any of the three conditions. So the citizenship concept is itself confusing and it needs or it demands attention. So if you are learning about citizenship, it is very much important that you are very much present in this moment so that you can understand what are the terms, what are the provision, because there are lots of provision, there are lots of criteria that has been mentioned on what basis a person can be a citizen of India. As you can see in point 1 itself, there are other categories that have been included inside. So first it says the person who had his domicile in India. So whenever we apply for certain job or certain civil service exam, so the requirement says that you have to have a domicile in India. That means you have to make it visible or make it happen that you are a person of Indian origin. That is the very first requirement. Then it says that in order to have this, you also need to some another requirements as well. That is, if he was born in India, if that person has been born in India, or if either of his parents was born in India, if he is not born in India, then it is important that his parents should be born in India. Then it says, or if he has been ordinarily resident in India for 5 years immediately before the commencement of the constitution become a citizen of India. If he is not from these two categories, then for at least 5 years he has to be resident of India. Then also he is eligible to become a citizen of India. Then we have a person who migrated to India from Pakistan become an Indian citizen if he or either of his parents or any of his grandparents was born in and divided India and also fulfill any of the two conditions. This again it says under point 2 there is also added certain more provisions which is needed in order to make the person eligible for becoming a Indian citizen. Condition if he might. So it says that conditions. First, a person who migrated to India from Pakistan. So this Citizenship Amendment Act 1955 is talking about a scenario from the ancient period. It does not have any relevance with today's era. This will be added in the historical background of Indian citizenship when the movie Gadar was came, when people were going from here and there because of the division. There were lots of chaos. People were confused. People were getting divided from their loved ones. So from that era, we are understanding the act. So it says that a person who is migrated to India from Pakistan, so between that division, if anyone went to Pakistan then later came to India, they can also be a part of Indian citizenship, but there also some have certain condition, that is in case he migrated to India before July 1948. So this is the specific date which is needed. He had been ordinarily resident in India since the date of its migration, or in case he migrated to India or on after July 1948, he had been registered as a citizenship of India. So these are the other requirements that is needed if a person has been migrated to India from Pakistan. But a person could be so registered only if he had been resident in India for 6 months preceding the date of his application for registration. So this whole thing you need to memorize in order to write what Citizenship Act 1955 talks about regarding citizenship. Then we have a person who migrated to Pakistan from India after 1947 but later returned to India for resettlement could become an Indian citizen. So same thing, just to say it, a person is coming from Pakistan to India. So a person is going from India to Pakistan, then says that, oh, I'm not liking this environment, I'm not liking this food, I'll be returning to India again. Then also he can be considered under the citizenship of India for this, but again it has a condition. For this, he had to be a resident in India for 6 months, preceding the date of his application for registration. So this is the requirement for such person. A person who or any of whose parents or grandparents was born in undivided India but who is ordinarily residing outside India shall become an Indian citizen if he has been registered as a citizenship on India by the diplomatic or consular representative of India in the country of his residence, whether before or after the commencement of the constitution. And it says before the division, if any of a person or his parent or his grandchildren were a part of this, then also such people are eligible to become a part of Indian citizen. Thus, this provision covers the overseas Indians who may want to acquire Indian citizenship. So, what is overseas Indians? This will also we will cover in our next slide. So this is all about the Citizenship Act 1955. So let's sum it up. So some of these provisions deal with the citizenship of a person domiciled in India. So now I have talked about the importance of domicile. Person migrated from Pakistan. So from people who have migrated from Pakistan later came to India. Persons migrated to Pakistan but later returned. So from such person who were in India, then they went to Pakistan, then they returned. For such people also we have provisions. Person of Indian origin residing outside India. So last this point talks about a person who has its Indian origin, but for some reason, for job purpose or any other purpose, they have been living outside India. For such person also we have other provision from using what they can be a citizens of India. The other constitutional provision with respect to the citizenship are as follows. No person shall be a citizen of India or he be deemed to be a citizen of India. He has voluntarily acquired the citizenship of any foreign state. So we all are well aware that Indian constitution does not talk about dual citizenship. So if any person, take citizenship from another country, from other country, then they cannot be a part of our country. Either we want it you as a whole or no. So that's the requirement. Every person who is or deemed to be a citizen of India shall continue to be such citizen subject to the provision of any law made by Parliament. Or any other person who is already a citizen of India, he will be deemed to be a citizenship of India until Parliament, came up with another law with amendment. So till then, he will be considered as a citizen of India only. Parliament shall have the power to make any provision with respect to the acquisition of termination of citizenship and all other matters relating to citizenship. So obviously, because this power has been given to them by the Constitution of India itself, so the Parliament, whenever they want, they can do amendment, they can do alteration, they can do whatever they want to. If they're feeling like this is the need of the hour, they will be doing so. So now let's. So till now we have understood Citizenship Act 1955. So we are going to understand it a little more in detailed way. The Citizenship Act 1955 provides for acquisition and loss of citizenship after the commencement of the Constitution. So its scope is basically to understand what is the acquisition and loss of citizenship under this Act. Originally, the Citizenship Act 1955 also provided for the Commonwealth citizenship, but this provision was repealed by the Citizenship Amendment Act. So it is basically the historical background of Citizenship Act 1955. Acquisition of citizenship. So by acquisition of citizenship can be taken by such some mode, and that is given here. The Citizenship Act 1955 prescribes 5 ways of acquiring citizenship. So there are 5 ways that have been mentioned by using what we can acquire Indian citizenship. That is birth, descent, registration, naturalization, and incorporation of territory. By birth, a person born in India on or after January 26, 1950, but before July 1, 1987, is a citizen of India by birth, respective of the nationality of his parent. So the dates we need to remember any cause if we are learning about citizenship. A person born in India in or after July 1, 1987 is considered as a citizen of India only if either of his parents is a citizen of India at the time of his birth. So it basically says that your parents has to be from India, be it your mother be or your father, any of the person has to be a citizen of India. Further, those born in India on after December 30, 2004 are considered citizens of India only if both of their parents are citizens of India, or one of whose parents is citizen of India and the other is not an illegal migrant at the time of their birth. So, as I said, Citizenship Amendment Act 1950 was based on the ancient era. Later, with time, with changing dimension of the society, the provision has been changed. And earlier, it was said that if both of your parents or if any of your parents from India, then you can acquire Indian citizenship. Later, it says that both of your parents has to be Indian origin, or if any of your parents is from India and other is from other country, then that person has not to be a migrated one. The children of foreign diplomats posted in India and enemy aliens cannot acquire Indian citizenship by birth. So enemy aliens we have already discussed in a previous slide. So when we talk about foreign diplomats, so there are such person who are posted in our country with some dignified or bigger post. So for their children also we are not giving any kind of citizenship under our Indian constitution. By descent, a person born outside India on or after January 26, 1950, but before December 1992 is a citizen of India by descent if his father was a citizen of India at the time of his birth. So any of his person, in order to make him the person of Indian origin, his parents history is very much needed if they are from India or not, be it their parent, be it their grandparents. A person from outside India or on after December 10, 1992 is considered as a citizen of India if either of his parents is a citizen of India at the time of his birth. December 3, 2004 onward, a person born outside India shall not be a citizen of India by descent unless his birth is registered at an Indian consulate within 1 year of the date of birth or with the permission of the central government after the expiry or the the said period. As I said, the term has been changed with time to time. So earlier it said if your parents from India, then okay, will accept you as it is. But later it says if he is born and he is not registered under Indian registry or Indian government, that person cannot be a part of Indian origin. An application for registration of the birth of a minor child to an Indian consulate shall be accompanied by an undertaking of in writing from the parents of such minor child that he or she does not hold a passport of another country. But for such minor, if his parents is making a decision on behalf of his because he is a minor, they have to give it in writing that their children is not part of any other country. Further, a minor who is a citizen of India by virtue of descent and is also a citizen of any other country shall cease to be a citizen of India if he does not renounce the citizenship or nationality of another country within 6 months of the attaining full age. So now about him, when he was child, his parents took his no, decision on behalf of his. But when he attained majority and he can decide that whether he want to be a part of India or whether he want to be a USA or Australia. So if he is registered under any other country and if he want to be the citizen of India, then he has to renounce his citizenship for that specified country. It is not relatable whether his parents is from India or by descent he obtain his Indian citizenship. So he has this kind of provisions or options that he can now take his own decision. Now let's talk about by registration. The central government may, on the application, register as a citizen of India any person not being an illegal migrant if he belongs to any of the following categories named. So as I already said, citizenship is a vast topic. It's like a kind of a tree. So like this is citizenship. Then this is not like a tree, but okay. No, my drawing skills are very bad. So a tree it has lots of branches. Like you can see from points inside it has also points. So in order to make it more understandable, we have to remember all of the important information regarding Indian citizenship. So now let's move into by registration. The central government may, on an application, register as a citizen of India. So these are the points. Let's see. A person of Indian origin who is originally resident in India for 7 years before making an application for registration. If a person is want to become a part of India, then they has to reside at least for 7 years in order to give their application. A person of Indian origin who is ordinarily resident in any country or place outside undivided India. For such person also we have provisions. A person who is married to a citizen of India is ordinarily resident in India for 7 years before making an application for registration. So you have to be here for at least 7 years. Minor children of person who are citizens of India. So this is basically talking about this minor. A person of full age and capacity whose parents are registered as citizens of India. See, they can this point also you can understand from this paragraph itself. A person of full age and capacity who are either of his parents was earlier citizen of independent India and is ordinarily resident in India for 12 months immediately before making an application for registration. The person of full age and capacity who has been registered as an overseas citizen of India, card holder for 5 years, and who is ordinarily resident in India for 12 months before making an application for registration. That is, they have to have a card holder, that is OCI card holder. A person shall be deemed to be an Indian origin if he or either of his parents was born in undivided India or in such other territory which became part of India after August 15, 1947. So any person who were from undivided India or whose parents or grandparents from undivided India, for such person also we have provisions. An example it has been given as all a person all the above categories of persons must take an oath of allegiance before they are registered as citizens of India. So, for all such person we have provisions. If you want to have an Indian citizenship, you have to go through all kind of provision, and what is suitable for you, we will give our citizenship on that basis. So now we'll understand by naturalization. The central government may, on an application, grant a certificate of naturalization to any person not being an illegal migrant. So, if he is or she is a illegal migrant, we are not giving his any kind of citizenship. If he possesses the following qualification, so it is up to the central government that he is not a subject or citizen of any country, where citizens of India are prevented from becoming subjects or citizens of that country by naturalization. If A is from Australia, I'm just giving an example, and people from India are not, you know, are not granted permission to go into Australia, and if any person from their place wanted to become our part of, why will give them? If we are not getting permission to enter into your premises, then also your people are not uh, getting entry in our places. That is as simple as that. That he is not subject or citizen of any country, where citizens of India are prevented from becoming subject or citizens of that country by naturalization. If you are not giving, we are also not giving. That if he is a citizen of any country, if he undertakes to renounce the citizenship of that country in the event of his application for Indian citizenship being accepted. If you are already a member of certain countries, and if you are not uh, willing to denounce that, so you don't need to come to India. That he has either resided in India or been in the service of a government in India, partly the one and partly the other, throughout the period of 12 months immediately preceding the date of application. That during the 14 years immediately preceding the said period of 12 months, he has either resided in India or been in the service of a government in India, or partly the one and partly the other, for periods announcing the aggregated laws that 11 years. So this is the how one can acquire citizenship through naturalization. That he is of a good character. If you have a good character, then okay, welcome to our country. That he has an adequate knowledge of a language specified in the eighth schedule to the Constitution. If you know any of the language that has been mentioned in the eighth schedule, that is also you are eligible by naturalization. That he, in the event of a certificate naturalization being granted to him, he intends to reside in India. So when the certificate is given to him, you have this intent, you have the will to live in India after rest of your life, or to enter into or continue in service under a government in India, or under an international organization of which India is a member of, under a society, company, or body of some person established in India. However, the government of India may waive all or any of above conditions for naturalization in the case of a person who has rendered distinguished service to the science, philosophy, art, literature, world peace, and human progress. So this is kind of exception. So if a person has, immense knowledge in any of this field, then they are also highly welcome in our country, because they may contribute for our good also. Every naturalized citizen must take an oath of allegiance to the Constitution of India. So they have to take an oath that they will be respecting our Constitution, our flag, our national anthem. Then only they'll be accepted as our citizens by incorporation of territory. So this is another mode. If any foreign territory becomes a part of India, the government of India specifies the person who among the people of the territory shall be the citizens of India. So it basically say that when our India was under British control, and there were certain areas which were under British, and these are the areas which we have considered as India. So what about these people? So if these people is belonging from that territory, then also they will be considered as India citizens. For such person become the citizens of India from the notified date. From such date, they can be considered as Indian citizens. For example, when Pondicherry became a part of India, the government of India issued the citizenship Pondicherry Order 1962 under the Citizenship Act 1955. So the example is already given here regarding Pondicherry. Special provisions as to citizenship of person covered by the Assam Accord. So basically, Assam Accord is all about Assam Sukti. So people from Assam will basically understood what Assam Sukti is. So which has been mentioned under Indian Constitution, or by in the amendment 1955. Special provision to city as the citizenship of person covered by the Assam Accord. The Citizenship Amendment Act 1985 added the following special provisions as the citizenship of person covered by the Assam Accord, which related to the foreigners issue. So there has been an issue regarding the illegal migrants because the people of Assam were facing issues because of the illegal migrants that were coming to our place. So on that basis, for that people also, this act has such provisions. All persons of Indian origin who came to Assam before the January 1, 1966 from Bangladesh and who have been ordinarily residents in Assam since the date of their entry into Assam shall be deemed to be citizens of India from the January 1, 1996. So, regarding Assam Accord, this is the important date that we need to remember. Every person of Indian origin who came to Assam on or after the January 1, 1966, but before the March 25, 1971 from Bangladesh, and who has been ordinarily resident in Assam since the date of his entry into Assam and who has been detected to be a foreigner, shall register himself. So if a person is an illegal migrant, he has to register himself. Such a registered person shall be deemed to be a citizen of India for all purposes of from the date of expiry of a person of 10 years from the date of detection as a foreigner. But in the intervening period of 10 years, he shall have the same rights and obligation as a citizen of India, excepting the right to vote. So for such people, we will be accepting them as our Indian origin, but they have not only one right, that is the right to vote. Loss of citizenship. Now we'll understand how we can lose it or how it can be renounced. The Citizenship Act 1955 prescribes three ways of losing citizenship. So it is given three ways, whether required under the Act or the prior to it under the Constitution. For example, renunciation, remuneration, or deprivation. By renunciation, any citizen of India of full age and capacity can make a declaration renouncing his Indian citizenship. Basically, any person who is major, he if he is not willing to be our citizen, then he can say that uh, I am renouncing my citizenship. Upon the registration of that declaration, that person chooses to be a citizen of India. However, if such a declaration is made during a war in which India is engaged, its registration shall be withheld by the central government. But it also has a exception, that is if it's happening during the war period. Further, when a person renounces his Indian citizenship, every minor child of that person also loses Indian citizenship. However, when such a child attains the age of 18, he may resume Indian citizenship. So if anyone's parents is renouncing their Indian citizenship, so basically their child also loses its Indian citizenship, but the child has the right if you want to be a part of our India after a certain period of time. So other form on what basis can be acquired or terminated, that is when an Indian citizen voluntarily, consciously, knowingly, and without duress, undue influence, or compulsion, acquires the citizenship of another country, his Indian citizenship automatically terminates. This provision, however, does not apply during a war in which in India is engaged. So during war is already an exception. So if a person is a part of Australia and also a part of India, then it would be already terminated because we are not offering any kind of dual citizenship. By deprivation, it is a compulsory termination of Indian citizenship by the central government. The central government also can terminate its citizenship if the citizen has obtained a citizenship by fraud, the citizen has shown disloyalty of the Constitution of India, and the citizen has unlawfully traded or communicated with the enemy during a war, the citizen has within 5 years of the registration of naturalization been imprisoned in any country for 2 years. The citizen has been ordinary resident out of India for 7 years continuously. So this is up to the government, the central government. If they found any of this following, then your citizenship can be terminated. Then let's talk about single citizenship which India provides. Though the Indian constitution is federal in vices, a dual polity center and state, it provides for only a single citizenship. This is the Indian citizenship. So as I said, Indian constitution only talks about a single citizenship. There is no provision for dual citizenship. The citizens of India owe allegiance only to the Union. There is no separate state citizenship. The other federal states like USA and Switzerland, on the other hand, adopted the system of double citizenship. So this is basically the differences between USA and Switzerland along with India. In USA, each person is not only a citizen of USA but also of the particular state to which he belongs. Thus, he owes allegiance to both and enjoys dual set of rights. One set conferred by the national government and another by the state government. This system creates the problem of discrimination. That is, a state may discriminate in favor of its citizen in matters like right to vote, right to hold public offices, right to practice professions, and so on. This problem is avoided in the system of single citizenship prevalent in India. So it basically talks about the provisions of the scenario in USA. If only we are talking about citizenship under Indian Constitution, we can skip this paragraph. If you want to have a vast knowledge regarding citizenship in other countries also, you can also understand it, but it is not necessary if you're talking about Indian, basically India. In India, all citizens, irrespective of the state in which they are born or reside, enjoy the same political and civil rights of citizenship all over the country, and no discrimination is made between them. So our country is all about unity, brotherhood. If you are the person of your citizen of India, you are citizen of that particular state. Also, there is no division in such matter. However, the general rule of absence of discrimination is subject to some exception, but it has also some exception. If you're talking about Indian Constitution, there is obviously the exception. That is the core of the Indian Constitution. Parliament under Article 16 can prescribe residence within a state or union territory as a condition for certain employments or appointments in that state or union territory or local authority or other authority within the state or union territory. According the Parliament enacted the public employment requirement as to Residence Act 1957 in there. But this is basically about Article 16. I have already discussed exactly what Barrack says about, so you can refer that paragraph. So let's skip this. The Constitution under Article 15 prohibit discrimination against sex, caste, race. This is also been explained. So I am skipping this part. Please refer to this previous para. So let's move into Article 19. The freedom of movement and residence under Article 19 is subject to the protection of interest of any scheduled tribe. In other words, the right of outside to enter, reside, and settle in tribal areas is restricted. Of course, this is done to protect the distinctive culture, language, customs, and manners of scheduled tribes and to safeguard their traditional vocation and property against exploitation. So we have certain exception for SC and STs, and why we have that, for that also we have certain reasons. Till 2019, the legislature of the 12th state of Jammu and Kashmir was empowered to define the persons who are permanent residents of the state, confer any special rights and privileges on such permanent residents as respect employment under the state government, acquisition of immovable properties, settlement in the state, right to scholarship on such other forms of aid provided by the state legislature. So this is basically talks about Kashmir till 2019. We are giving them special status because for some reason they needed it and we have given it. But after that period, the uh, scenario changes. The above provision was based on Article 35A, which talks about Constitution of India. The article was inserted by the Constitution Order 1954. This order was issued by the President under Article 370 of the Constitution. So there is also a movie under Article 370, I guess. You can watch this to understand this thing more clearly with filmy vibe, which has provided a special status to the erstwhile state of Jammu and Kashmir in 2019. This special status was abolished by a new presidential order known as the Constitution Application to Jammu and Kashmir Order 2019. This order superseded the earlier 1954 order. So the Constitution of India, like that of Canada, has introduced the system of single citizenship and provided union reform, except in few cases for the people of India, to promote the feeling of fraternity of unity among them and to build an integrated Indian nation. So we have a similarities with Canada sometimes. Despite this, India has been witnessing the communal rights, class conflict, caste wars, linguistic clashes, and ethnic disputes. Thus, the cherished goal of the founding fathers and the constitution makers to build an united, integrated Indian nation has not been fully realized. Now, let's talk about OCI, that is Overseas Citizenship of India. In September 2000, the Government of India, Ministry of External Affairs, had set up a high level committee on the citizen Indian diaspora under the chairmanship of L.M. Singh V. The mandate of the committee was to make a comprehensive study of the global Indian diaspora and to recommend measures for a constructive relationship with them. So, what about OCI? For them also, we have certain provisions. In the year of 2000, the committee submitted its report to January 2002. It's recommended the amendment of the Citizenship Act 1955 to provide for grant and dual citizenship to the persons of Indian origin belonging to the certain specified country. So this committee basically talks about that 1955 amendment Citizenship Act should be amended and there should be given dual citizenship to the person who are overseas citizenship or overseas citizen or overseas people from India. The country submitted accordingly the Citizenship Amendment Act 2003 made provision for acquisition for overseas citizenship of India OCI by the PIOs of 16 specified countries other than Pakistan and Bangladesh, which also omitted all provisions recognizing or relating to the Commonwealth citizenship from the Principal Act. So this basically talks about what should be the provisions for the people with overseas citizens of India. For that, the report has been made, and on report only such recommendation has been taken. Later, the Citizenship Amendment Act 2005 expanded the scope and grant of OCI for PIOs in all other countries except Pakistan and Bangladesh, as long as their home countries all dual citizenship under their local law. So this is all about OCI and you know PIO. What should be their status? It must be noted here that the OCI is not actually a dual citizenship as the Indian Constitution forbids dual citizenships or dual nationality. So it says for what about the people who have been resident in other country? Because Indian Constitution does not talk about dual citizenship. So it creates lots of confusion at that time. Again, the Citizenship Amendment Act 2015 has modified the provisions pertaining to the OCI in the Principal Act. It has introduced a new scheme called Overseas Citizen of India Card Holder by merging the PIO card scheme and the OCI card scheme. So there were lots of confusion who are with the people of OCI, who are PCI. So PIO. So for that, the card holder scheme has been introduced in that era. The PIO card scheme was introduced on August 19, 2002, and thereafter the OCI card scheme was introduced with effect of December 2005. Both the schemes were running in parallel even though the OCI and card scheme had become more popular. This was causing unnecessary confusion in the minds of applicants. Keeping in view some problems being faced by applicants and to provide enhanced facilities to them, the Government of India decided to formulate one single scheme after merging the PIO OCI scheme. So that's because there were lots of confusion. So the government thought about merging both of them in one particular area, containing positive attributes of both, and achieving this objective, the Citizenship Amendment was made. Act 2015 was enacted. The PIO scheme was rescinded with effect of January 2015, and it was also notified that all existing PIO card holders shall be deemed to be OCI card holder with effect of January 9, 2015. The Citizenship Amendment Act 2015 replaced the nomenclature of Overseas Citizen of India with that of Overseas Citizen of India card holder and made the following provisions in the Principal Act. Registration of overseas citizen of Indian card holder. The central government may, on application made in this behalf, register as an overseas citizen of India card holder. So this is the provision on what basis you can consider to be part of that. Any person of full age and capacity who is a citizen of another country but was a citizen of India at the time of the commencement of India. For such people, we have this provision. Who is a citizen of another country but was eligible to become a citizen of India at the time of the commencement of the constitution based on the eligibility, who is a citizen of another country but belong to a territory that become a part of India after 15 August 1947, who is a child or a grandchild or a great-grandchild of such a citizen, a person who is a minor child of a person mentioned in clause A. This is here a person who is a minor child and whose both parents are citizen of India and one of parents is a citizen of India, spouse of foreign origin of a citizen of India, spouse of foreign origin of an overseas citizen of India card holder whose marriage has been registered and has subsisted for a continuous period of not less than 2 years immediately preceding the presentation of the application. So this is all about the OCI card holders. So this is the requirement or this is the provision that has been mentioned for them. The central government may specify the date from which the existing person of Indian origin cardholder shall be deemed to be also India cardholders. Notwithstanding anything contained in point 1, the central government may, if it is satisfied the special circumstances exist after recording the circumstances in writing, register a person can an overseas citizen of Indian cardholder. Conferment of rights and overseas citizen of India cardholder. An overseas citizen of India cardholder shall be entitled to such rights as the central government may specify in this behalf. So this is all about the central government and it is the responsibility of no of their only. An overseas citizen of India card holder shall not be entitled to be following rights. So they are not be entitled for some rights and that has been mentioned here, which are conferred on the citizen of India. He shall not be entitled with the right to equality of opportunity in matters of public employment. So this is the exclusion. He shall not be eligible for election as a president because they are OCI. He shall not be election of vice president, eligible for appointment as the judge of Supreme Court, appointment as the judge of the High Court, registration as a voter. So all these things has been, not considered for them. He shall not be eligible for being a member of the House of the People of the Council of State. He shall not be eligible for being a member of the State Legislative Assembly or the State Legislative Council. He shall not be eligible for appointment to public services and posts of connection with affairs of the Union or of any other except or appointment in such services, and central government may specify. So these are rights is not for them. Renunciation of overseas citizen of Indian card. So now how they can be renounced? If any overseas citizen of India card holder makes in prescribed manner a declaration renouncing the card registering him as an overseas citizen of India card holder, the declaration shall be registered by the central government, and upon such registration that person shall cease to be overseas citizen of India card holder. If someone voluntarily says that I don't want to continue my role as an overseas citizen of India, therefore I'm renouncing it voluntarily. That is another method where a person ceases to be an overseas citizen of India card holder, spouse of foreign origin of that person who has obtained overseas citizen of India card, and every minor child of that person registered as an overseas citizen of India card holder shall thereupon cease to be overseas citizen of Indian card holder. Cancellation of registration of overseas citizen of India card holder. So how that can be cancelled? The central government may cancel the registration of a person as an overseas citizen of India card holder if he satisfied that the central government has all the authority to do so. The registration of an overseas citizen of India card holder was obtained by means of fraud, false representation, the concealment of any other method. So this is similar with that any person can, renounce his termination being an Indian citizenship. So they will be applicable for ACI also. The overseas citizen of India card holder has shown disaffection towards the Constitution of India. So if you are not showing respect to our Constitution, flag, national anthem, then also we don't want to make you a part of our country. The overseas citizen of India card holder has, during any war in which of India may be engaged, unlawfully traded or communicated with an enemy. If our country is having war with some alien country, and you are offering gadgets to that country, then on that basis also we can terminate it. The overseas citizen of India cardholder has, within 5 years after registration, been sentenced to imprisonment for a term of not less than 2 years. It is necessary to do in the interest of sovereignty and integrity of India, the security of India, friendly relations of India with any foreign country, or in the interest of the general public, or the marriage of an overseas citizenship of an India card holder has been dissolved by the accompanying court of law, or otherwise, or has not been dissolved, but during the substance of such marriage she has solemnized marriage with any other person. So, if any of the ground is found by the central government that they can cancel the OCI card holder at any moment they want. So this is basically all about the citizenship, which took me exactly an hour to explain it to you. I don't know was it worthy or not. So if you wanted to understand the citizenship, you have to be very attentive. As I said, it has point inside point. It has lots of dates to remember. It's has lots of amendment. So that's all about today. Soon we'll be meeting with another video. If you watch this video worth watching, please do share and subscribe. That will be meant a lot to me. That's all for today. Thank you for watching.